as I understand the law.
In your opinion, has DA Willis been forthcoming or transparent with you and the commission as to her utilization of special assistant district attorney in this election integrity case?
Well, to the extent that this is all new ground for us and for all of us, and
that's because it wasn't utilized by the prior district attorney for the last 20 years before her election.
well, this whole issue with election integrity, election interference, and all of that is new territory for us, and we're sort of, feeling our way as we go through this, even with the trying to work down the backlog of cases that we had. So we were sort of making up rules as we went along, to be honest with you.
Sure. Do you worry that she was utilizing resources for prosecuting a election integrity case rather than getting rid of this backlog of 40,000 criminal cases?
Would you repeat that?
Does it worry you that she was spending significant resources without prior approval or even any reporting or accountability pursuing an election integrity case rather than working on this backlog of 40,000 criminal cases that were pending in Fulton County? It might have been 56,000. I can't remember all my numbers. It was a lot total.
Well, as I said earlier, and as the CFO said earlier, we appropriated $75 million of the $206 million of the ARPA money that we received to the justice system. And she had, in addition to the backlogs, she is currently involved with the YSL case and the election interference case. So those were, three really unusual cases that I had never experienced before. So we were trying to be as helpful to her as we can and could by providing, for the most part, the resources that she asked. But as far as what happened to the resources, the money, when I say resources, I mean the money that we gave we, after it was given to her, we tracked the cases, the backlogs, and the jury is still out on the YSL and the election interference. So we'll get it all come out in the wash, I suppose, as to how effective it's all been. But we provided what was asked for, and we've not asked for, nor have we been provided any interim reports as to how we're proceeding, other than with the backlogs.
So she hadn't really told you how she spent the money?
No, sir.
Okay, so you gave her $75 million plus at least another $5 million.
Well, it wasn't just to her. There was a whole justice system at $75 million. Right?
That's
yes,
correct.
it wasn't just to her.
You gave her many millions of dollars to get caught up on a backlog of criminal prosecutions.
Yes.
Okay. And when you did that, there was no mention of any election integrity case, was there? That didn't really ever come up specifically, just this one sounding for additional money in 2023.
I believe that's correct. When you say that's correct.
Yeah.
The $1.1 million for Tex MacGyver and public corruption is the only thing that could specifically have reference to an election integrity case.
In her enhancement request, yes, sir.
And it wasn't in her budgetary request either, was it? Anything about election integrity?
It would have, if it was for additional resources, it would have come through as an enhancement request.
So as a commission, you weren't aware that you were funding a election interference case, certainly not before 2023, which would have been 3 years after the election.
I think that's correct.
Okay. And you haven't been given any information to tell you where the money that you did give her through ORCA funds or other things were spent.
Well, whatever part of that $75 million that she received, and whether how much was used for the backlog, how much was used for the YSL case, and how much was used for the election interference case, and we don't know.
Yeah.
And we're not being given any information other than with the backlog. Now,
Is
that's probably easier to quantify. I don't know how she would give us, or any district attorney for that matter, would give us a report on how the case is going until it's concluded.
Understood.
Yeah.
But she could have told you how your money was being spent that you had awarded to her, whether it was being spent on the backlog of cases versus public corruption cases versus, Tex McIver or whoever. She would have been able to give you that data.
Could have, yes, sir.
But she didn't.
Did not, and we didn't ask either.
Okay. And that's partly because she's taken this stance that she's a constitutional officer and doesn't have to give you that information.
That's probably a correct statement.
Okay. Well, let me turn to you, Ms. Joe. You and I have had conversations before today about whether or not a district attorney has to get prior approval and authorization of funding from the county commission when utilizing this independent contractor, special prosecutor device that the legislature gave the ability through Title 15-18-20A. You heard me read that relevant portions of the statute, and you would agree just at face value that would seem to require a DA to obtain approval from the governing authority before hiring an independent contractor?
Yes, sir.
Okay. But I think, make sure you're on.
I would agree that the plain language of the statute certainly seems to indicate that the governing authority needs to be consulted and approve such an appointment.
Right, now, so tell us who you are. You're the county
sorry.
attorney. Give me just a little bit of background on you.
My name is Sue Joe, and I am the county attorney for Fulton County, which means that I am the essentially in-house general counsel for the corporation that is Fulton County. And my office handles civil matters for the entire county, provides defense and legal advice and counsel to the Board of Commissioners.
And in your role as county attorney, were you ever asked to interpret this statute or do legal research to find out whether or not Ms. Willis should have gotten prior approval or whether she was required to do that before going out and hiring independent counsel?
I don't recall if there was a specific request, but of course I keep up with current events, and when this issue came up, I did have the occasion to look into the matter and research it.
Give us your legal opinion as to whether or not prior approval is required. You've agreed that the plain language of the statute would indicate that. Have there been judicial interpretations of this statute that cloud those matters?
So let me begin by saying that the statute, OCJ 15-18-20, that you were reading from, deals with assistant district attorneys. So it's not explicitly giving the DA permission to appoint special assistant district attorneys. In case law, that statute has been... It does say
independent contractors, though, right?
It does,
okay.
which we, that is the classification for special prosecutors in Fulton County in terms of how they are employed.
Is there another statute that specifically addresses special independent counsel or prosecutors, whatever the phrase
I have
is?
not found one. And what I was going to say is that the case law that I have reviewed that has interpreted this statute says that while it is not explicitly mentioning special assistant district attorneys, that is included in the general authority provided under the statute to district attorneys. So in at least 3 Georgia Court of Appeal cases, what I have found is that the court has rejected the proposition that this particular statute requires a district attorney to obtain explicit permission from a county prior to appointing a special assistant district attorney. And in fact, the original case, the court noted that...
Give us that citation, because
so
this is kind of instructive to the legislature. Do we need to amend this statute to clarify? And so you help me with my legal research. What's that citation?
So I'm sure the Attorney General's office would be happy to provide their official advice, but what I will, I'll begin by just saying what the citations are of the 3 cases that I reviewed. One of them is Greater Georgia Amusements at 317 Georgia Appeals 116, which cites to State versus Cook at 172 Georgia Appeals 433, and is referenced again in Amusement Sales Incorporated versus State of Georgia. And if you'll excuse me, let me look at my Westlaw. Okay, that's going to be at .316 Georgia Appeals 727. And all of them include a construction of OCGA 151820 that indicates the DA does not ADA does not have to have explicit permission from the county in order to appoint a special assistant district attorney, and that the employment may be pursuant to whatever private arrangements regarding compensation are mutually agreeable to the district attorney and the appointee. That is a quote from State versus Cook that is contained in Greater Georgia Amusements.
Okay. So judicial interpretation of our statute essentially eviscerate the plain meaning or language of the statute.
Well, I will say I was definitely surprised at the construction in that it seems to be at odds with the plain language of the statute, but that is the current state of Georgia law as far as I can find it.
Okay. And in your role as county attorney, do you seek approval from the Board of Commissioners for hiring, we'll just call them outside counsel, to represent the county's interest in certain civil matters?
Absolutely. That is considered, that travels under a separate ordinance regarding the engagement of outside counsel. So, for example, it could be an official of the county is sued, requests representation. If there is some reason why my office doesn't have the capacity to take it on directly, I may recommend the engagement of outside counsel, and I will bring that to the Board of Commissioners for their approval.
Okay. And that's pursuant to a county ordinance that requires that type of approval of both funneled through your office and submitted to the county commission?
Yes, sir. The Fulton County Plan of Defense governs what types of circumstances in which we can provide defense as a county, and also the way in which that provision is made. It is either made through my office or through outside counsel. Even if it is provided through my office, I still go to the Board of Commissioners, present the case, indicate why it's covered under the Plan of Defense, and ask for authority to represent.
Is there a similar county ordinance that references or applies to prosecutors?
There is not.
Okay. So you only refer back to the state law for that?
Yes.
Okay. In your role as county attorney, are you responsible for responding to open records requests?
Yes. The custodian of records was established in recent years and centralized as an individual who's designated from among the attorneys in my office.
So that is an attorney that responds to those complaints?
It is an attorney who oversees the response operation.
So that's under the control of your office then, or?
The intake and coordination of the response is within my office, the county attorney's office. Obviously, we are not the custodians of most of the documents that are requested, so we have to coordinate that, with designated open records liaison within each custodial department.
Do you, in your office, respond to open records requests submitted to the district attorney's office?
She has the ability to handle the entire open records process separately from the county as a state official. Historically, the district attorney's office has both utilized my office as the point of origin and liaison, and then at times has chosen to opt out of that. Currently, this district attorney for Fulton County does receive her Open Records Act request through the Open Records custodian in my office.
And if counsel is needed to respond to those requests or object to them or litigate disputes over open records requests, is that something provided by you for the district attorney, or does she handle that herself?
So having it routed through my office is a fairly recent circumstance with our district attorney's office, but now that it is within my office, any questions as to exemptions and what is subject to public disclosure under the Open Records Act would be referred to my attorneys in my office, and we would assist with that and provide guidance.
And is your office actively providing guidance or legal counsel to the DA's office in any open records requests or litigation arising from those at this time?
At this time, yes.
Okay. Does she opt out of utilizing your services on occasion? Handle them in-house, so to speak?
I did not mean to imply that it was a case-by-case basis. There was a period of time in which the point of contact was not my office. My office was not involved in the process. But as of, I would have to check to confirm when, but it would be at least several months ago, perhaps a bit longer. She has opted to utilize my office as the initial point of contact and to provide that type of guidance again.
Was she using your office for point of contacts and guidance and sort of legal services during the open records requests that Ashley Merchant submitted this past fall?
I would have to confirm that. I don't know exactly when that came in.
Okay. But here in the last few months, District Attorney Willis has begun to utilize your office as the point of contact for receiving open records requests and for responding to them?
That's not exactly accurate. For receiving and for coordinating and providing advice, but in many instances, the custodial departments will upload their own responsive documents. So when we advise them of what is being requested, provide any legal guidance that may be necessary, are a point of contact for communication to provide status updates to the requesting party. But because the custodial department may have more immediate access, or if it is in the case of voluminous responsive documents or documents with restricted access within those departments, the department itself is often the ones who will upload the documents into our software that is used for Open Records Act requests.
So if I submit tomorrow an opens records request to the Fulton County District Attorney's Office, maybe I want to find out what happened to those 16,000 cases that ORCA was supposedly funding. Who will respond to that? Does the DA's office respond to me, or do they route it through you and you give me a response?
My expectation would be that someone on the Open Records team in my office would be the initial point of contact and say, thank you for your request. We understand you've requested XYZ documents. Either here are your documents, or we estimate that it will take a certain amount of time to gather the documents that we believe are responsive and within our custody. And then that they would keep you updated or be available should you call in or email in with a question as to status.
And if the district attorney did not want to provide the documentation I requested, would she object to that, instruct you to object to that, or does your office make that determination?
So I don't know that we have a long enough history to have a representative sampling of all the different potential circumstances, but my expectation of the process would be that we would communicate what was requested, that her office would identify whether or not they had responsive documents, and that they would work with my office to identify the subset of those documents that do not fall under any type of exemption, for example, pending investigations or any of the statutory exemptions that are provided for in state law.
Okay. And so what happens if she says, I ain't giving that information up?
I am not aware of such a circumstance. In some instances, the response we get from the departments may include, we do not have any responsive documents. And that is how sometimes disputes arise, because the requesting party may believe that they exist, and the custodial department asserts that they do not exist.
Okay, what if they say, yep, they exist, but nope, I'm not giving them to you? You know they exist, your custodial people figured it out, it's public records.
To my knowledge, that response has not occurred. But if it did, I would expect my open records team to review the statutory obligations under the Open Records Act with the custodial department to emphasize and impress upon them their legal obligation to provide the documents that are subject to the Open Records Act.
Okay, thank you. Let me ask you about the county ordinance concerning reporting of gifts from vendors or independent contractors. Does Fulton County have such a policy?
I believe, and I haven't reviewed that specifically for today, but I believe you are referring to the prohibitions that are contained in our ethics code.
Yes. So
Yes,
what does your ethics code of Fulton County provide as far as the receipt of gifts from independent contractors or other vendors of the county or its agencies?
I mean, if I could have a moment, I could try to pull that up, but just off the top of my head from previous reviews, there's a lot of language in our ethics code about appearance of impropriety, appearance of conflicts, avoiding appearance of conflicts. So my advice, if I were asked, would always be to avoid it altogether. However, there are certain customary gifts, chocolates at Christmas time, Christmas gifts, etc., things that are shared among everyone in the office. As long as it's of nominal value, and I believe the cutoff is $100.
That sounds
There is a nominal value that is allowed under our ethics code, but anything of significance beyond that is considered to be prohibited.
And is it prohibited to receive it, or are you required to report it?
I can't recall if it's a report. I want to say it's a reporting requirement, and the reason I can't recall is because I like to stay as far away from the line as possible, so my preference would be to not receive it. But it may be a reporting requirement. If you would like a certain answer, I can check either on a break
Sure.
or at some
I'll
point
let you
in
do
proceedings.
that for me. Do you believe that ethics code applies to the district attorney or other constitutional officers of Fulton County?
I'm not sure what the intent was when the code was originally enacted, but I know that there has been a determination by the Board of Ethics, which has purview over adjudicating matters relating to the ethics code, that it does not apply to the district attorney. And in a related occurrence, we have had a recent piece of legislation updating the ethics code in Fulton County to add, I believe the amendment is a sentence that specifically indicates that the ethics code applies to all elected officials in Fulton County.
Do you know why? Why this clarification?
I did not, I was not the sponsor of the legislation, so I cannot speak for the commissioner who sponsored it. But I do know that it was subsequent in time to the decision of the ethics board that the district attorney was not covered by our code of ethics.
So there was an ethics complaint brought about the receipt of gifts, and it was determined that your existing ordinance or code, ethics code, did not apply.
Yes, sir. The Board of Ethics determined that it did not have jurisdiction under the current ethics code.
And the county commission has subsequently here in recent months amended that ethics code to make it clear that it does apply to constitutional officers such as the DA and the sheriff and the tax commissioner.
Yes, I believe that was passed on April 17th or thereabouts.
Very recently. All right, Mr. Chairman, tell us about that.
Well, I can't add anything to what the county attorney has said. It came about, and I supported it when it came up. There's some loopholes, so we're trying to close all loopholes.
Is it and so that is now, has been enacted, a recent ordinance or ethics code for the county?
Yes, sir.
And it now does require the district attorney and other constitutional officers to disclose gifts of more than a nominal amount.
I think that's how it's worded. But it covers the district attorney and others, all elected officials.
Right. What about reporting of gifts that are above $100 or a nominal amount? Are you required to report those or simply banned from receiving them?
I'd have to check the exact language in the code.
Sue will be looking while we talk. So just on a sort of philosophical level,
Yes, sir.
why do you feel like that was needed or that type of ban is appropriate for elected officials, including constitutional officers?
Well, I wasn't the sponsor of the legislation,
Right.
but
You voted for it?
I voted for it, yeah, to close any loophole, so to remove any doubt as to, who's covered, who's not covered, because the idea is for us to be open and transparent about what we're doing.
Okay. And is there an appearance of impropriety if you were to receive kickbacks or things of benefit from folks that were contractors or vendors of the county?
Okay, repeat that one.
Is there an appearance of impropriety or wrongdoing for elected officials to receive kickbacks or things of benefit from vendors or independent contractors of the county?
Well, I would say if it's over whatever that amount is, then that would be a problem.
Okay. And is the reason is that your independent judgment and acting on behalf of the people brought into question if you're receiving things of benefit from those that you're doing business with?
Well, I mean, we want to be above reproach. I guess that's used quite a bit by elected officials, and that's the intent, so that we are above reproach and that we are open and fair in our dealings. And we have blackout periods where we cannot even contact to those who are seeking to do business with the county.
Even though it was recently determined that the ethics provisions did not apply to constitutional officers, did DA Willis fill those type of disclosure forms out, those gift forms, in the past?
I'm not aware of it. I don't know about that.
Okay.
I've not seen.
What about
Any violence.
Paul Howard? Did he fill those type of forms out in the past?
I have no knowledge of that. Yeah.
Yes, he wasn't using independent contractors anyway, right?
I don't recall him using the special prosecutor. So I'm not aware.
Has the
But
county?
I have not reviewed what other elected officials are, reporting.
Has the county commission ever come in and asked any agency heads or constitutional officers to terminate or void or alter any contracts with independent contractors or vendors?
Okay, repeat the question.
Has the county commission ever come in and asked for department heads or constitutional officers to terminate or void or amend or change any contracts that they might have entered into with independent contractors or outside vendors?
The question is, has the county ever asked someone to void an independent vendor contract? I don't know that that's, we've not, no, all you did was pull the funding. You did not
Yeah.
for the contract?
Here's a recent contract, not, excuse me, not involving the district attorney, but we didn't ask the department head to. We did not ask the department head to terminate the contract. We simply terminated the funding of the contract, and the effect of that was to terminate the contract.
And in Ms. Willis's case, you wouldn't have been able to terminate her contract with Mr. Wade because you can't control the funding of that?
All right, let me make sure I understand the question.
So Ms. Wade had a contract with Mr. Wade to be special prosecutor as an independent contractor. And you have not asked her to terminate that agreement. The judge ultimately did, but a county commission never.
The board did not.
Okay.
No, sir.
And was that because you approved of that arrangement, or because you didn't think you had the authority to require her to terminate that arrangement?
Because we did not have the authority, because she had the authority to hire the special prosecutor.
When did that first come to your attention, or the board's attention, that she had entered into a contract for a special prosecutor, Mr. Wade, to handle this election integrity case?
Me personally?
Yeah.
During the media coverage on it.
So you didn't even know it until the media erupted back in the fall sometime?
That's correct.
What was your response or your reaction, both personally as in your capacity as chairman of the commission?
Well, since we believe that we did not have any control over her decisions, that it was her decision to hire the special prosecutor, that we had no role in it.
Could you have cut the funding off for that, just like you did this other contract recently?
We didn't know anything about it.
So it had not even been disclosed to you as a commission?
No, sir.
Okay. What are your views on the propriety of elected official hiring somebody under an independent contract arrangement that they had an intimate personal relationship with?
Well, here are my personal views on.
Yeah.
I think I believe our revised code of ethics covers a situation like that. It's been amended. Is that correct?
The revised code that you support would prohibit that, right?
Yes.
Okay.
It was, the definition, I think, was expanded to include personal relationships.
Yeah. Ms. Joe, can you elucidate us any on this? You're leaning forward in your seat as if you might have some information for me there.
I did not intend to lean forward like that.
Be careful, I'm watching.
I don't want to speak for the chairman, but I believe the recent enactment that he is referring to is a new anti-nepotism policy
Right.
that would cover personal relationships of this nature between an official and an independent contractor.
Okay. Is that a new ordinance as well? Or
It
has that
is.
been there?
It is. Our prior ordinance was located within the Civil Service Act, so it was limited in its application to employees and would not have applied to independent contractors.
Would it have applied to employees of the DA's office?
Yes.
Okay. So if Mr. Wade had been hired as an assistant DA, it would have violated the then existing nepotism policy?
Assuming that they had that type of relationship, yes.
I think that's been admitted by both parties at this point, right? You keep up with the press, correct? I mean,
Yes, but in our hypothetical, I mean, it depends on the timing.
So the amendment was to expand on your existing anti-nepotism clause that would prohibit superior from having a relationship, intimate relationship with an employee, to include independent contractors in that ban?
In effect, yes,
Okay.
it expands it, but it had to do it through a separate policy because the original policy is within our Civil Service Act and therefore limited in application to employees. So there is a separate policy that is a county-wide application that prohibits all of the same things that also applies to independent contractors because it is not limited by the scope of the Civil Service Act.
And that was enacted when?
I believe that would also be April.
All right.
Was it April?
So both of
April
these,
17th as well,
both of these, your ethics policies, your anti-nepotism, your gift,
have recently
Yes.
been expanded.
and they were expanded to capture this type of situation that we're dealing with here with Ms. Willis and Mr. Wade.
Had they been in place, both would have captured this, would have applied in this instance.
Okay. And was there any rationale for not including independent contractors in the past, or was that just an oversight?
That is well, I will say these are all fairly well-established older policies, but as to the anti-nepotism policy specifically, I think the limitation is simply where it was located, which is the Civil Service Act.
And because it was located in that act, it was not deemed
It
to
could not apply to anyone but employees.
Okay. Do you know whether the District Attorney's Office has a separate sort of ethics guideline or ordinance or rules?
I'm not aware. I presume there are state guidelines that would apply as being a state officer, but I'm not aware of any that are specific to her office.
Okay. One of the things that was brought forward in one of our previous hearings is that Ms. Willis entered into an independent contract for essentially a publicist, a PR firm to help guide and monitor publicity. Is that the type of contract that the county would need to approve or fund?
I'm not aware of that contract, but it would, again, back to this constitutional officer and her being somewhat of a constitutional officer. I mean, there's a sheriff, the tax commissioner, and a couple of others that are a little different from the district attorney. But if she had, and your question is about the district attorney,
Yeah.
if she had the funds in her budget, then she could, without coming to us, coming back to the board seeking approval.
Did she ever ask for funding for a PR firm out of New York City in her different budget requests? Is that anything in the line item, Ms. Whitmore? She was asking for $36 million. She explained part of it would be spent for a New York City PR firm to monitor her publicity.
Not that I recall. I would have to research that.
Mr. Chairman, is that something that the Board of Commissioners would ordinarily approve or budget for various departments?
Well, again, if that's not something that we would, as a matter of course, routinely be aware of, and I can't recall ever of a request like that coming before the board. But if it's in a department's budget, particularly a constitutional officer's budget, and he or she feels that that's what they need, then if they have the funds under this umbrella of a constitutional officer, they can do it.
But you're the one that has to approve those funds, because I can assure you that's not in our state budget.
Well,
We don't give PR money to DA's offices.
We wouldn't be funding that specific line item. We would be funding whatever she requested. Then once the money is approved, then the constitutional officer, once the constitutional officer's budget has been approved, they can make changes as they deem appropriate.
Does your Board of Commissioners have a contract with any type of media monitoring service or public relations service?
Does the Board of Commissioners?
Yes, sir.
As a board, no, sir.
Okay. Would you approve that type of funding if she had specifically requested it?
Would the board have?
Yeah.
I mean, I can't speak for the entire board, but knowing the board as I do, probably not. For the purpose that you've outlined, probably not.
Okay. You learned, I guess, the same way the rest of us did back in the fall as essentially the media reported this relationship between Ms. Willis and Mr. Wade. What type of pressure was put on the Board of Commissioners, or was it anybody complained to you, or was it frustrating that you couldn't do anything about it? I'm curious what the reaction was from the board when all this scandal erupted.
Well, there's no pressure on the board per se. I mean, individual constituents, may have commented, here and there, but there's no, I didn't feel any pressure. Obviously, people would comment on what they had seen or heard or read, and I'm sure that's true for the rest of the board as well, but no pressure.
Yeah. You've kind of explained here today that the board really has no supervisory authority or control over how Ms. Willis spends the dollars that you budget for her, but the public had the presumption, until you're clarifying it here now, that the board approved this device of using an independent contractor as a special prosecutor. It helped fund this election integrity case, and a number of attorneys, both private contractors and assistant DAs, being engaged in it, and endorsed or didn't disapprove of the relationship between Mr. Wade and Ms. Willis. What is your reaction or response to that? Just kind of like you told us today that that's out of your control. You may not approve it, but can't stop it or prevent it.
Well, you just said a lot now, and,
Yeah.
and I can't,
I'm sorry about
can't follow all of that.
All right. Okay.
So if you could repeat, I mean, the last.
Maybe I can break it down.
Yes, sir.
Do you feel like the Fulton County Board of Commissioners supported this election integrity case, or 16 cases, either by financially supporting her to pursue those cases?
Well, I don't think the board, the board had no position or has no position on it. The district attorney, as I understand how district attorneys operate, they are free to choose the cases that they get involved in.
Okay.
And we as a board have no input into that.
You were never educated about that before the fact,
About
those prosecutions, election integrity cases?
I mean, was the board informed that
Yeah.
the district attorney was going to?
You've made it clear she didn't specifically ask for funding for that prosecution or for the hiring of special assistant district attorneys to lead that prosecution. Did you
That's
even
correct.
know that was happening and that you were funding that, even if it was in the big chunk of money?
No, we're not advised of her work program, if you will. I mean, we provide funding for her, and she sets her own work program, and I think that's probably true for, as I understand it, for all district attorneys.
Okay. There was testimony before us in previous meetings about Ms. Willis and Mr. Wade making trips to Washington, D.C. to meet with the Justice Department, and in Ms. Willis's part, I think, meeting with the Vice President of the United States. Does, I guess this may not be best for you, but I guess, Ms. Whitmore, were you aware of any expenditures for that? I mean, that was paid for with taxpayer money. Is that something that's reported, or you track that they're spending your general funds to travel and meet with the Vice President and the Justice Department?
We do record their travel expenses. I was not and have not reviewed the district attorney's office travel, the details, so I had no knowledge of what her individual, travel arrangements would have been, but their travel requests and transactions are, if they're paid for out of county resources, there is a reconciliation process that is undertaken by the traveler. If they're using the county's procurement card or travel card to pay for the travel, then there is a detailed process that they have to go through for that. But at my level, I'm not necessarily involved in looking at or reviewing any of those transactions.
Those type of travel expenses, do they require any prior approval by the county or by your office?
Our travel policy allows the elected officials to approve the travel for their staff and to approve the travel for themselves.
And you mentioned the procurement card. Is that what we call a P card?
Yes, sir. We use both a P card for non-travel related credit card purchases, and then we have a separate card that we call a T card, T for travel. So departments have both, one for basically goods and services and one that is for travel. So the county's policy is a reimbursement-based policy, so the traveler can pay for their travel expenses directly and seek reimbursement, or the county will prepay using the T card, and then the reconciliation process follows the trip.
Explain that reconciliation process. Let's say somebody uses a T card to take a trip to California or whatever. It gets charged directly to the county through that essentially credit card?
Yes, every department has a single travel card holder.
Okay.
And the individual traveler is required to coordinate their travel needs with the travel card holder. Travel card holder makes all of the arrangements and charges for that card, and the traveler, if they're traveling for official county business, is expected to return and supply through Concur. We use the Concur platform for our travel reconciliation process. They're expected to provide the receipts, hotel, evidence, if it was a conference, evidence that they attended the conference, and any other receipts that they may have where they are seeking reimbursement. So that is, when I refer to the reconciliation process, that is what I'm referring to from the traveler's perspective. And then each month, the travel card holder is required to pull their bank statement for the card and complete the reconciliation process for that bank statement for that period, so that we can process payment to the financial institution that we use for our credit card purposes.
So is Ms. Willis the T-card holder for the district attorney's office?
I don't believe she is, no, sir.
Okay. So it would be some designated employee of the DA's office would handle that?
Yes, sir.
And at the reconciliation stage each month, they would submit the receipts from each member of that agency or department that had utilized the card?
For the charges, they would need to submit the requested documentation for the charges on the card for that statement.
Okay. Are there limits as to say, will you put somebody up in a Ritz-Carlton versus a Holiday Inn? Are there caps on how much you're allowed to spend on lodging or travel?
Our policy does outline those type of limitations, yes, sir.
And if somebody exceeds those limitations, do you simply cut the reimbursement off at whatever your cap is or your guideline calls for?
If they have requested an exception, so say they're traveling to an area and there are no hotels available, it's a conference, there are no hotels available at the host hotel, and they have to move to a different location, and the rates are higher, they can ask for an exception to that and seek approval for that. But otherwise, they may be charged back for those costs that are outside of the allowances allowed through the travel policy.
Does the department head have the power to override those allowances, create exceptions, as I think you said?
Exceptions are required to be approved in advance and by the county manager or his designee.
Do these rules that you've just outlined apply to the district attorney's office?
These rules apply to anyone who travels using the county's, seeking reimbursement from the county using the county's travel policy or the county's T-card.
Who is the custodian of these documents, the reconciliation process and the payments made under the various T-cards and P-cards?
The purchasing department is the administrator of the T-card and P-card program. Ultimately, the final reconciliation packages are received and retained by the finance department.
Are they under your purview?
Both of those are, yes, sir.
Okay. So you could get me that information if I properly requested it?
Yes, sir.
Okay. Mr. Pitts, you are on the audit committee of the commission.
Yes, sir.
Is that by virtue of your position as the commission chairman, or is it a subset of the commission? How's that created?
Let's see. I think it's a 5-member committee, I believe, and 2 commissioners sit on that committee, and they're appointed or nominated and appointed by the board.
And currently, you are on the audit committee?
Yes, sir.
Okay. And is Bob Ellis the other commissioner?
Yeah.
Right.
Commissioner Ellis is chair of the audit committee.
And who would the other 3 members be then, if you are the 2 commissioners?
The private citizens.
And what's the authority or the power of that audit committee? What's the role of the audit committee?
Well, we work with the county auditor, Mr. Anthony Nix, and to provide audits for various departments, areas when we see or feel that need to be looked into from an audit point of view, whether it's financial or programmatic or otherwise.
I know only what I've read in the Atlanta Journal-Constitution about this, but apparently there was a recent audit report that had been requested by the audit committee.
Yes, sir.
Tell me about that. What was that audit for?
I believe you're referring to the audit that was done at the request of the audit committee. We utilized an outside firm called Cherry Beckert, nationally recognized firm, to look at and review and it wasn't really an audit, it was a review of our primarily purchasing requirements and processes within the county, and looking at all departments, but focused in on the sheriff's department and the district attorney's office in particular.
And did that Cherry Beckert, is that
Beckert,
how you,
yes, sir.
Did it produce a written audit report of its work?
It did.
Okay. And was that presented to the commission?
Yes.
Or just to your committee?
No, it was presented to the commission, and we had 2 representatives from the firm make a presentation to the full board a couple of meetings ago, maybe 3 meetings ago.
Did this audit reflect any irregularities or improprieties in spending by the sheriff's department?
There were, I'm going from memory, we can make the full report audit. Well, it was really a review and not an audit, but it was an audit firm, nationally recognized firm. And again, they focused on the sheriff's department and the district attorney. And there were 2 sets of recommendations, and I don't recall the specific recommendations, but with respect to the sheriff, I think they used a term of, do you remember the term? Was it high? High power. Is that it? Yeah. So the conclusion was the county sheriff's office risk level, they call it, was high, and it lists certain areas. And with respect to the district attorney, the risk level was medium.
Did it list particular areas that there was a medium risk for impropriety by the district attorney's office?
Well, I can read from the document here. The use of prosecutorial discretion as a justification comes with the risk of it being used with greater frequency, with more purchases being made over time outside of county rules and procedures.
And that expenditures that we're talking about?
Purchases.
Okay, are those
Yeah.
purchases using a P card or a T card, or is it identified?
Probably a combination of both.
Ms. Whitmore?
Prosecutorial discretion are typically the items that the district attorney engages in directly. Expert witnesses, if there's any special evidence processing that has to take place, any visual aids maybe that need to be supplied as part of trial, any extraordinary trial expenses. Typically, the district attorney engages and secures those goods and services outside of our county procurement process, which is the reference to the prosecutorial discretion, I think is the word that they use.
Mm-hmm. That's correct.
Would that include travel expenses for witnesses being brought in from out of state?
Those should be following the county's travel policy. It does have a section that deals with extradition and witnesses. Again, but it applies if you're using the paying for it with county resources, seeking reimbursement, or using the county's travel card.
Would that include special prosecutors, independent contractor prosecutors?
The DA's use of prosecutorial discretion, yes.
So that's captured by this category that
Yes.
the audit report is saying
Yes, sir.
you got some moderate potential for abuse here. Did they specify any particular expenses that seem to be inappropriate in this report or this review?
Probably in the larger report, there were some instances, but I'll have to provide that to you, because that's not in this document that I'm looking at now.
Okay. Ms. Whitmore, have you provided that document? You've given me a book full of things. I don't know how much made it to it yet, but you're still in progress.
I have not. The subpoena asked for audits.
You don't consider this an audit, and it's just a review?
Yeah, it was a review, so I did not include it. But
Could you voluntarily provide me a copy of that report that you have, as well as the full report, this review?
Sue, is that sufficient? Yes, yes, sir.
Okay, thank you.
Noting it now.
I'm sorry, what?
I appreciate that. There were a number of references to Ms. Willis having significant expenditures for her personal security detail. Is that something that was presented to you in a budget request?
So, repeat that one, sir.
There has been testimony before the committee about the district attorney, Ms. Willis, having significant expenditures for a personal security detail that may even travel with her on these trips that she takes. Is that something that was presented to the commission as a part of a budget request, the cost of that?
I don't know whether or not, as a matter of course, the district attorney has a security detail. I don't know the answer to that.
Did Mr. Howard ever have a security detail?
I know that he had, we had some security enhancements around his home at one point because of some threats that he'd received.
Okay.
Now, with respect to District Attorney Willis, again, I don't know whether she routinely had a security detail or whether we paid for one. But in this particular instance, because of the YSL trial in particular, and the
What does YSL stand for?
Young Slime Life, I believe. Isn't that
Okay,
correct? Is that
so
right?
that's
Young Slime Life.
That's the gang-related
Correct.
prosecution's been going on for a year now.
Yes.
Okay, got it.
Because of that trial and the election interference, it came to us in executive session that she was receiving, as were a number of us, me included,
Yeah.
particularly during the election back in 2020. I had a detail with me, but because of the YSL trial and the election interference, she was receiving threats, bodily harm, pretty serious. So a report was made to us about that in executive session, and a request came to us on her behalf to provide additional security for her. And after listening to what was going on, we, the board, listened, and then in open session decided and voted to provide additional security for her.
What's the cost been for that additional security, and is it continuing up until today?
I don't know whether it's continuing, but do you have the cost of the security?
As I recall, the full ask that was presented included relocation, as well as some hardening of her personal residence, and law enforcement support from at least 2 outside jurisdictions. I don't recall what all of the amounts were, nor can I tell you that I have seen an invoice from either of those other external jurisdictions. The relocation costs run about $4,000 a month.
Was that relocation cost renting her this condominium where she and Mr. Wade would meet?
I don't know the physical address of either of those locations, so I really wouldn't be able to answer that question.
Do you know who you were making the payments to for this, for the rent?
We do. I do not, but I certainly know who we cut a check. Well, I know how to obtain who we cut a check to,
Okay.
but I don't see those expenses every month.
Has that continued, the relocation expense? I mean, essentially, the county is providing extra security at her personal home, but also renting her a separate location she can live in or sleep at. And I'm not going to ask you to disclose that location. I'm just Is that continuing?
The expenses are continuing.
And how long have they been going on?
I believe they began in the later portion of 2022. I don't recall the exact date. I would have to research that.
All right. Thank you. Ms. Joe, you had mentioned this, I don't know if I'm calling it a civil rights office, but what is the county's structure for receiving complaints of employment discrimination against the county or any agency of it?
So employees who have complaints regarding their employment conditions have a couple of different possible routes. One of them is DCRC, and now I am blanking on what the acronym stands for, but I think it's the...
Diversity and Civil Rights Compliance.
Okay, so it is, we've
Diversity and civil rights compliance?
Yes, we've kind of outsourced our initial point of contact for EEOC type violations internally. And that is done outside of my office. And then at some point in the process, we may get involved later on down the road. But it begins at DCRC. And then we also have a whistleblower hotline that is established that routes to our county auditor. And whistleblower complaints can be investigated in that manner as well. So those are the two
by the auditor
primary
or
routes.
DCRA?
DCRC.
DCRC, okay. Is that a confidential process?
I would say so. It is confidential even from me at the outset unless it develops into litigation or an EEOC complaint. So it should be confidential from the employee's point of view when they present the complaint.
Does the employee's employer learn of such a complaint? Some type of employment violation?
Employer meaning their manager or whoever they are, the subject of their complaint?
Right.
I would not expect that person to be made aware unless and until there's a point in the investigation where that becomes necessary in order to obtain necessary information.
Like their explanation or defense?
Yes, when they would be made aware of the complaint in order to provide a response.
Okay. And insofar as the whistleblower hotline, that's confidential as well, I would presume?
Yes, under state whistleblower laws, the identity of the whistleblower is kept confidential for as long as possible.
And does the county have its own whistleblower policy?
The county does also have a whistleblower policy.
Is that a written policy?
I have not looked at it in probably over a decade.
Wow.
I believe it's an ordinance that mirrors the state whistleblower statute, but I would have to confirm that.
Does it prohibit retaliation against somebody for bringing forth a complaint of impropriety or wrongdoing?
Yeah, I would expect that it does include that, because if it mirrors the statute, then it would include the anti-retaliation provisions.
So how long have you been with the county attorney's office?
2.5 years as the county attorney, and then 10 years prior to coming back as the county attorney, I was a line attorney in the office for 4 years. So.
Okay. What do you make of this constitutional officer argument, so to speak, that constitutional officers are not subject to any supervision or control by the county commission?
So, are you asking for my personal opinion or my understanding of the state of the law?
I'd love to have them both. Let's start with the law, because
Well,
we may be looking for ways to change laws, and I'd be interested in your personal views from your experience.
So, as to the state of the law, I will say that the challenge presented for my office, for the board, and to some extent I would imagine for the officers involved, is that there is this inherent conflict created by the state of the law, wherein there are certain elected officials who are essentially embedded with the county, provided facilities by the county, provided either employees or supplemental employees by the county, equipment by the county, a budget for operations by the county. Those officials must interact with the county, for example, in order to process payment vouchers. They have to come back to the county even in instances where they may have independence or latitude in contracting, for example. They still need to come back to the county finance department in order to get a check cut, in order to pay on these contracts that they may have control over, but they can't cut a check directly to the vendor. So there is this kind of built-in tug of war where two parties who are essentially operating independently, one is funding another without any necessary input or oversight into the process or any of the contracting, but essentially is on the hook when it comes to processing the payments, when it comes to supplementing budgets after the fact in order to make up for budgetary shortfalls because of those expenditures, and ultimately may be left with the legal liability and exposure should there be any issue with the way in which those services were obtained. So I do believe there are some practical and legal challenges for all counties and elected officials who are in this kind of in-between state where you have independence, but you depend on the county for finances and processing, and where the county has an obligation to fund, but doesn't have any control over ensuring any kind of standards or protocols in the expenditure of those funds.
Very well stated. If you are probably as knowledgeable in this interface of the county governments and state elected officials or county elected officials, in the case of a DA, as any attorney around, if you have suggestions to our committee on how we might could clean this up a bit through statutory amendments or modifications, please feel free to give those to me. Okay. And while I have you there at the witness chair, I, as the county attorney, I have mentioned to you sort of pre-meeting, if there are any documents that you have produced to us so far, you've got the whole notebook in front of you, or that you may produce in the future as you complete the document production that you feel like contain confidential personal information or otherwise privileged information, please identify that to me. You've been so good here to have all these documents bait stamped so we can very clearly identify which pages you're talking about. Then I will treat them as confidential within this committee. We will not be making these documents public other than available for review of committee members until I hear back from you, hopefully in the next week or two.
Thank you,
Fair
Mr.
enough?
Chairman.
Okay, thank you. At this time, I am going to turn the chair over to you, Madam Leader, or any designate of the minority party if there's additional questions anybody might want to make at this time.
Thank you, Mr. Chairman. This is Mike 9 that Senator Harold Jones will.
Harold Jones, all right.
Question number 10.
You got
Oh,
it.
you got 10.
And also, no, not 10.
You're recognized,
And then
Senator
also,
Jones.
and there's also, can Senator Estevez also asked a couple of questions too? It'll literally be like one. But I may cover all of them. Okay.
Tell them to hand
So,
it to you, just
I got
like
you.
Dolezal's been giving them to me. We're trying to follow the rules.
Yeah, I've been noticing that. He's been writing a
my
bunch.
assistant, just like the
He's been
chairman
writing a
has
bunch.
several assistants. So.
I was just looking at the code section 151820, because that is one of the things that we maybe have some purview over. So the issue about the district attorney and the spending, now that has been really the law in Georgia for forever. I mean, even the case that you cited, the amusement sales case, that case cites a case that goes all the way back to 1984, which makes clear that this language about may should not be read as a shall at all, that it is a may, and that basically it's an agreement, is it not right, between the district attorney's office and the county and the local governing authority of how they do this. And that's been how we've been operating for years in Georgia. Is that not correct?
Yes, I would agree that the construction that's contained in the 3 cases that I mentioned has been well established since at least the 1980s in Georgia.
And when we talk about trying to change that, one of the other offices that would come under that particular change, if we change this particular statute, would also have to be the sheriff's officers too. They would also have to be changed too. I guess in degree of fairness, we wouldn't just change one office, would we?
So I'm not sure that an amendment to this statute would impact them, since it is specifically about a district attorney's authority to hire assistant district attorneys.
Well, in reality, isn't it actually what we're really talking about is the constitutional office, not necessarily just district attorneys? Or are y'all only making the position that the district attorney should be subject to a change and no other constitutional office should be subject to a change? I'm asking all 3 of you.
So repeat the question.
Is the argument that only district attorneys as constitutional officers should be subject to a change, but no other constitutional officers should be subject to a change as far as their spending patterns are concerned?
No, it's not. It's not specific to the district attorney.
Okay.
It's the issue that I have, and I just be in all openness, honesty. My position is different from that of my colleagues. I have a philosophical difference with this notion of a constitutional officer being able to spend money that the legislative body has appropriated any way that he or she chooses. It may be, I understand the words, it may be legal, but being gay was illegal at one point. Interracial marriage was illegal. Segregation, well, not illegal. Yeah, well, that's illegal. Discrimination was legal. So I have a philosophical difference with that. I think that we appropriate money, and I'm not singling out the deal, it's all of them. That's the difference. So my colleagues don't see it as I see it.
I understand, but to be consistent, it would have to also include the sheriffs
Absolutely.
too. Absolutely.
And the tax commissioners, there's 4 of them, right?
Yes, and also the clerk's office.
And the clerk's office.
It would include all of those.
Right.
Yes.
This may be splitting hairs, but I do want to clarify that the constitutional officers under the county constitutional officers are just the 4, the sheriff, the
That's
probate judge, the clerk of the Superior Court, and the tax commissioner. We would consider the district attorney to be a state constitutional officer, which is some
But
differences.
They have the same kind of purview over their budget as the others do, as far as
They
like-
have some additional latitude and independence than other elected officials, yes.
The sheriff, wait a minute, you're saying the sheriff doesn't have latitude in his budget?
I'm saying that I just want to make sure that we understand that the sheriff and the other county constitutional officers don't have exactly the same independent rights as the state the state constitutional officers.
And I'll clarify
rather than lump
that
them all together.
OCGA 151820 applies only to the district attorney.
Yes.
It's by its very, on the face of it, it doesn't apply to clerks and tax commissioners and sheriff's departments.
And the statute has nothing, it's not based on the fact that she is a state officer or state constitutional officer. It's just based on the statutory authority of all district attorneys.
But Mr. Chair, as far as like when you're talking about the budget process, you would say that those, especially sheriffs, they do have that opportunity to kind of control their budgets. Is that not right? Have they not also used the same argument that you cannot control their budget? Has the sheriff ever told you that? Mr. Chair?
Oh, me?
Yes.
Okay, I'm sorry. I thought you were asking the county attorney.
Has the sheriff ever came to you and said that you also do not have purview over his or her budget?
Absolutely.
Absolutely.
Yeah, absolutely.
That's what I thought. Absolutely. 100%.
The 4 constitutional officers and the district attorney, who is a state constitutional officer. Yeah, the 5 of them there. They all say that. And,
Absolutely.
And again, my philosophical difference with that is, it doesn't make any sense to me that we don't have, can't tell them or have no control over how they spend their money. We appropriate the money based upon specific requests. and it's approved based upon specific requests. So when they get it, then they believe they can spend it any way they see fit, and I just disagree with that.
And also, just along those same lines, the only thing that's, well, one of the things that's a shell in this particular statute is that the district attorney actually shall be able to actually define the title of the person that she hires or he hires. They are able to do that and also fix that compensation. So that's the only shell really in here as far as this statute is concerned. Is that not right? That they have the opportunity to fix the title as far as the title that they're going to give the other employee that they hire. So with Mr. Wade, is it not right? Or anyone else, any other district attorney, they can give them any title that they want to as far as the statute is concerned. That was perfectly within the district attorney's purview.
Okay. Which subsection are you citing from?
Yeah, the district attorney shall define the duties and fix the title, line 7 on subsection A.
Oh, I see.
So that's completely within his or her purview to do that, according to the statute. To fix the title, to determine what they're going to prosecute.
Yeah, that is what the statute
Right.
says, yes.
So he or she would not have to come to the county commission to say that I want to have a special prosecutor for a specific event, whether it's election integrity or anything of that nature, because he or she shall be able to fix that particular title in their job duties. Is that not correct? That's correct.
Mm-hmm.
Okay. Also kind of looking at this from a liability standpoint, and I'm just curious, from a liability standpoint, if you guys were to start having more control over the district attorney's budget, is there any concern, I'm asking the county attorney, is there any concern from a liability standpoint? Because you have a lot of these cases where persons would sue the district attorney, sue the sheriff, but also sue the county. And the case law says, well, they're separate entities. And so therefore, you can't sue the county, you guys, for what the sheriff does or what the DA does, because they're separate. And what the court would do is go through a litany of things to show the separation. And one of those is that you guys don't control the budget of the DA or the sheriff. Would there be any concern that that separation then would leave? And now all of a sudden, when somebody sues the district attorney's office, they might be to sue you too. Would you have that kind of concern?
So one of my least favorite things is running a complete legal analysis on the spot, because
Sure.
I don't think it's very thorough. But just as an initial matter, as a practical matter, we are always sued with the official in most cases. We frequently provide representation under our plan of defense. Once we undertake representation, we also provide payment of the judgment, should there be one. So we are already on the hook, so to speak, if we are sued with them. I think, and to make it clear, I don't know that any of us are here to take a position on what should be done. I think that is within the purview of your body to make legislative recommendations. But an argument in favor of more control might be that if we are on the hook for the liability, that it is, we don't have any control over the actions of the officials who are generating the potential liability, but remain on the hook for providing defense and also payment of the judgment.
But normally in those cases, you guys are actually dismissed, and there's actually a question about, especially for sheriffs, whether you're actually technically on the hook or not.
Once
The
we
county will pay it, but
once
it's not necessarily
okay,
key.
I will say this. In the
Yeah.
27 years that I have worked in government defense, I have never known any of the governmental entities I have worked with not to pay the judgment, should there be one after we have undertaken representation. And under the current iteration of our plan of defense in Fulton County, once we undertake representation, unless there is cause and we discontinue representation, we would be providing payment of the judgment, should there be one, or settlement.
But from a standpoint of being sued, Mr. Chair, would that give you any concern that when a district attorney now is sued, they're also going to they can legally bring in Fulton County if you guys started trying to dictate salaries. There's a possibility that could happen. Would that give you any concern?
Probably.
Okay. And I bring that up because just in many cases, but in 2023, you have a federal court case that says County has to be dismissed because the law in Georgia shows that exclusively that the district attorney is a separate entity from the county. And one of the things that they point out is that the district attorney controls the compensation, and counties only possess the power to approve the amount. And so I guess my point just is, you said would concern you, if you get into the business now of actually trying to control compensation, it might just do an intermingling. And that's just a question that I had, and you answered it. Someone had spoken about the open checkbook. Can you kind of tell us about that? That you were saying you could go online about the open checkbook. Can you kind of tell us what that is?
It's an open part of our open government platform. If you go to the county's website under Inside Fulton, it's like on the far right, Inside Fulton, scroll down from that, you'll find a button that you can press that will take you to our open government platform. We have open budget where you can go and look and see what the budget and actual expenditures are. Open checkbook, I believe it goes back 5 years, includes vendor payments. It's updated. Currently, I believe it's updated on a weekly basis. But that information has been out there for a while.
In fact, go ahead.
We've had a service interruption as a result of our cyber incident, so we're just now, in the last week or so, been able to bring that back online.
Yeah, because my colleague over here is totally fascinated by it, because you can actually pull up every every law firm or whatever that's getting business in real time and see exactly what their bills are, can you not?
You can see their payments,
right,
yes.
Right. You can actually see their payments amount up to, I believe, you said it's updated weekly.
Yes, it should be updated weekly.
So a lot of the questions that we have as far as like payments and openness, it seems to me that you guys actually are very open, doing way more than Richmond County, quite frankly, that you guys are very open as far as how this process works.
We have been working on our transparency for a while now, but yes, we try to have as much information available as possible.
Anything else? That's good. I don't have anything else, Mr. Chair.
Senator Jones, while we got you here as an ex-solicitor, how is a solicitor's budget handled? Is it the same as the DA's or different? Is it? It's a similar situation. Solicitors are elected by the people for their judicial circuit, or are they on a county basis or a judicial circuit?
Oh, well, if you have one, you're on a county basis.
Okay.
Because every county does not necessarily have to have a solicitor.
They would only have that if they had a state court.
Right.
Okay.
Yeah. So the way our budget works
Who pays the
is
solicitor and the
county.
assistant solicitors? The
County,
counties?
yes.
Totally.
County, totally.
Okay.
And so the way it works is you just put your budget request in, and they approve it or don't approve it, which normally they're going to approve it. And they give you a lot of discretion. Now, can a solicitor have the same opportunity to say as a constitutional officer?
That was my next question.
I know.
Yeah, I don't know.
Do we have that same opportunity? No, but it also is a prosecutor's office, so normally they're more open as far as hands-off, exactly.
Yeah, allow for
They're always going to give more
discretion,
latitude as far as that is concerned, especially on prosecutorial discretion. Yes, absolutely.
So no state funds go to fund the solicitor or assistant solicitors, as far as
If it can be like a victim's assistance grant or something of that nature may be in there, but
domestic
other than
violence
that,
prosecutors.
right, if you had like a
stuff.
domestic violence, that might be in there. That's something new that was around when I was there, but primarily you're going to the county.
That has been sort of banging around in my mind when you started talking about all the different type of courts that the ORCA funds went to. Some of those are county only, like your magistrate court, your municipal court, your state court, whereas Superior Court system, now you're into state salaries, et cetera. Okay. Y'all have been fantastic and very patient and very cooperative with our committee, and we appreciate that. Thank you all for being here today, and I will await any additional documents that you might be able to produce to me. And Ms. Joe, of course, if you'll let me know about anything that's privileged or confidential before we put anything posted to the public site.
I will, and I also committed that I would look at the ethics code regarding
you.
gifts and honoraria, and I wanted to let you know that I did find the sections that I was thinking of.
All right, you want to tell me?
Yes, I will go through it real quickly,
Sections.
hopefully. So there is a prohibition of any officer or employee to solicit or receive any gift from a prohibited source. The prohibited source is defined as someone, among other things, who is seeking official action from or seeking to do business with the county. As far as the disclosure requirements, every year there are certain officials who are required to file a financial disclosure. This includes all elected officials of Fulton County. And one of the things that is required to be reported is any honorarium from a single source in an aggregate amount of $500 or more. And it also includes going back to the $100 or less for nominal gifts that are excluded from the prohibition. If you receive something of value of $100 or more, that should be included in your disclosure as well.
Does that have an ordinance number?
Yes, it is.
Code section number?
It is Code Sections 2-67 and 2-69 and 2-79. All of those are part of our ethics code that are codified as ordinance for Fulton County.
What do you call the disclosure form you mentioned? I guess it's a gift disclosure, an honorary, or whatever.
It's an annual financial disclosure. The section is entitled Disclosure of Income and Financial Interests. So you list any income you make outside of the county and other real property that's owned, and any gifts that were received, any financial interests that are covered in these sections A through C need to be included in the disclosure.
And that is required to be filed by the district attorney as well?
As an elected official, she would be required to file. I am required to file. Most of our executive team is required to file.
Ms. Whitmore, have I requested that, in your opinion?
You have. And it's included in your binder, Section 11.
Thank you so much. All right.
Partially included in Section 11.
I understand it's a work in progress, and I know the cyber attack has been a problem and whatnot. Y'all doing everything we can. Committee members, I apologize for the late notice of this meeting, and I appreciate y'all's efforts to be here. I am looking at my calendar now for a potential next meeting, and I wanted to bounce off of you guys the dates of May 23rd or 24th. That's a Thursday, Friday, 3 weeks out. If you don't have to tell me right here on the spot, but if y'all would please check your schedules and let me know, because I certainly want to accommodate everybody that's spending their time with this committee, and just bounce it back off to me or my admin, Cindy, and we'll let you know in the next week or so if we're going to be able to have that. And with that, we are adjourned. Thank you.
Thank you.
With you, the Chief Financial Officer of Fulton County. So I appreciate your cooperation with me to arrange a good time where we could be as less inconvenient to each of you as possible. I also want to thank you for your responsiveness to a subpoena that we had issued that asked for maybe more information that even I recognize might be responsive to it. And I have a notebook here that you've provided with us, and I understand there will be additional documents coming. If you want to just supplement those, I've spoken with your county attorney as able here in the next few days or weeks. I would appreciate that. But I did want to thank you for making the effort to be responsive on relatively short notice here. And thank you for being here with us today. Would you just introduce yourself and have Sharon introduce herself to the committee, please, sir?
I'm Rob Pitts. I chair.
Hang on, let me make sure I got you lit up here. There we go.
All right. I'm Rob Pitts. I chair the Board of Commissioners of Fulton County, Georgia.
All righty. And Sharon?
Good morning, Sharon Whitmore, the county's Chief Financial Officer.
You can pull that microphone closer to you if you want to. We had a little difficulty last meeting. Sometimes the volume's kind of fading in and out a little bit. That will allow us to hear you clearly. And also, this is being streamed live, and so anybody that may be watching on their computers at home will be able to hear the testimony that you give. I am going to start with a couple of formalities here. We have in your folders, ladies and gentlemen, the minutes from our first two meetings. The first one was held on February 9th, 2024. The Secretary of the Senate has prepared these minutes, and maybe a little tedious of a job, but easy because we are recorded, and so it's very easy to verify the accuracy. I did notice, Senator Estevez, we misspelled your name on one of them, I think, and we will two on both of them. We will correct that. And I told them, you being an attorney, it's going to be hard to slip anything by you on these, so we will correct those spellings as part of any approval of these meetings. Have you all had an opportunity? We sent these out in advance to review these minutes before today. Any committee members need additional time to review them before we take action? All right, then I am open for a motion to approve the minutes of the February 9th, 2024 meeting.
So moved.
All right, I've got a motion by Senator Dolezal. Is there a second?
Second.
Second by Senator Kennedy. Any discussion or any review, proposed changes or corrections to the minutes of February 9th? All right, then all in favor, raise your hand. Any opposed, like sign? All right, those are approved. Now turning to the March 6, 2024 meetings. Has everybody had an opportunity to review these thoroughly? All right, is there a motion?
Move to adopt the March 6 minutes as presented.
And with the amendment of the spelling correction, accept that motion. Is there a second?
Second.
All right. Any further discussion on that? And likewise, we will vote. All in favor, raise your hand of approving those minutes. Any opposed? All right, they are unanimously adopted. You'll also notice in your folder just a copy of our Senate committee rules. I put these in here because we did have some questions posed to us from the Fulton County Commission as they were preparing their responses to make sure what their timeliness was and how to object. I would like to state to you, Chairman Pitts and Ms. Whitmore, y'all should be aware that we have confidentiality rules on this committee. If there are any documents responsive to our subpoena that you feel like contain confidential information that should not be disclosed to the public, because we are creating a public record here, please identify those to me, and I will, in accordance with our rules, deem them confidential and shielded from public view. I know that just in conversations with your county attorney, I know Sue has told me there are certain things that she has redacted in these, if anything that dealt with the birth dates, social security numbers, health information of any of the employees of the county. And that is certainly fine. That's what we're trying to accomplish, to make sure that we are protecting documents that should be confidential, but also obtaining the records that we need to complete our investigation, and with the understanding that the vast majority of anything we ask for are in the public domain anyway. These are public government records that should be accessible to the general public, but also to the state Senate to conduct our work here. So thank you, and just let me know before we post anything on the website, any documents, if there are any that you feel like need to be shielded or protected in any way. Fair enough? All righty. Before we get started, I will need to swear each of you in. Mr. Pitts, I'll start with you. If you will raise your right hand, please, sir. Do you swear the testimony that you will give before this committee this morning will be the truth, the whole truth, and to the best of your knowledge and ability?
I do.
All right. And Ms. Whitmore, would you likewise? You swear the testimony you'll provide this morning will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
We have our court reporter present. We'll be making a transcript of all the testimony, and we're happy to share that with you. It will become part of the public record afterwards. If you later want to correct any answers or add information, we welcome that. And I will state before we begin, as we say every meeting, that our Senate website is set up that if anybody from the public has information you think might be relevant to our investigation, feel free to reach out to us and provide any information that could be relevant to us, and let us know if you would like to testify before this committee as our process unfolds throughout the summer and the fall. Mr. Pitts, let me get you just to give us a little brief background. You and I know each other,
Yes,
and I think most people in Fulton County know of you from your long history of public service. If you would tell us a little bit about the position you hold and how long you've been in the chairman's post and any other political service before that, I think it might give some context.
Thank you, Senator, Mr. Chairman. I've been, as you've indicated, been involved as an elected official for many years. I look at Senator Butler, and I kind of count sometimes to figure out just who is still standing. And I'm sorry that you're going to be leaving us. But I began my political career in Atlanta as a member of the Atlanta City Council. I served there for 20 years as a member of the Atlanta City Council. Then I was elected as president of the city council. I served 4 years as president. Then I moved over to the county, where I served for, I think, 12 years as a member of the commission, as a commissioner. And for the last 7 or 8 years, I have been privileged to serve as chair of the Board of Commissioners of Fulton County.
All right. And as in that position, how often does your commission meet? Is it twice a month?
We meet the first and third Wednesdays of every month.
Okay. Is it part of the duties and responsibilities of the Fulton County Commission to establish the budget for the district attorney's office and some supervision of that office?
We establish the budget for the district attorney as well as all other departments for final approval.
And when you're formulating the budgets, does the district attorney submit to you a budget request for public funding?
The process, and I'll defer to our chief financial officer, but there's a process where the department heads appear before the manager and the finance team to explain their requests, and then from there it comes to us for final approval. We might want to clarify.
So the budgets of all the county departments, including the district attorney's office, are ultimately approved by the county commission?
That's correct.
Okay. Ms. Whitmore, if it's okay with you, I may bounce back and forth between witnesses because I understand, as the chairman just deferred to you, there are areas where you have particular expertise. Okay.
Yes, that's fine.
Brenda, I'm not going to make your life as miserable as you're sitting there thinking right now. Our court reporter is going to try to keep a transcript, but you will occasionally have to go back and forth between witnesses. I will have, I'm going to have Ms. Whitmore later, a direct line of questioning her, but I may periodically let her chime in here, okay? All right. Sharon, tell us a little bit about that, how that budgeting process works.
Thank you, Mr. Chairman. Chairman Pitt's description is the general process. Actually, every department of county government, including constitutional officers and elected officials, submit an annual budget request through our budget development application. Those requests are reviewed, vetted, and verified through our budget office. The county's budget ordinance is designed in a way that the budget is developed and presented to the Board of Commissioners as a recommendation from the Office of the County Manager. So we have a review process that we undertake with the county manager and members of his executive team to review the requests that are presented Typically, we provide each agency with a base budget figure to start with, and then they are allowed to submit what we call budget enhancements, where they can ask for additional resources to just continue an existing program, to expand an existing program, or to establish a new program or service. We also have a separate process that we run simultaneously as the operating budget for a capital budget requests, and there is a capital budget review committee that receives and vets all of those requests, and they are then in turn taken into consideration at the same time as operating budget requests, because we only have one pool of resources to use, so we consider all of those at the same time. So our constitutional officers and elected officials submit their requests through the same channels. Sometimes they may choose not to come and present to the county manager's office, and then choose instead to communicate their budget needs directly with the Board of Commissioners. So that, in a nutshell, is the county budget process.
And when you talk about capital expenditures, is that like new automobiles for police departments, new buildings, new expenditures on things along those other than personnel?
Yes, sir. Rolling stock, heavy equipment, facility renovation, new facilities, facility expansion, all of that would come through our capital portal process.
So when we talk about building a new county jail, that's a capital project?
That is one very significant capital project, yes, sir.
Can you give us just a feel for what the size of Fulton County's annual budget is?
All funds included, it's about $1.2 billion.
And do you have readily available what amount of general funds from the county are allocated to the district attorney's office on an annual basis? I guess we'll just talk about this year to start with.
In 2024, the district attorney's allocation was $36.6 million from the general fund.
Okay. Chairman Pitts has tried to explain to me that there are several buckets of funds that are used to fund the district attorney's office. Would you kind of run that through for me as to what additional funding over and above the $36.6 million of general funds from county tax revenues that are allocated to the district
Yes,
attorney?
sir. The district attorney, in addition to the county's general fund resources, also has resources that are available through the confiscated asset forfeiture fund, as well as the victims witness assistance fund, federal asset forfeiture funds, and we keep all of these in separate funds, and then a number of different grants that come through the state and federal grant process. And then since really the middle of 2021, when we developed our spending program for the resources that we received through the American Rescue Act, the district attorney has also had resources available for what we call our Project Orca, which is our court backlog project that was funded out of our ARPA resources.
Okay, let me slow down on that one just a minute. Did you say Project Orca, like an orca whale?
Yes, sir.
Okay. Is that acronym, does that stand for something you could help tell us?
It's more, I guess, visual than that. It just was intended to mean that it was a very, an orca is a very large ocean mammal, and the court backlog that we had as a result of the slowdown in the court system during the pandemic was also very large. So individual who was charged with developing a program to address the court backlog, named it Project Orca, but it is our official court backlog reduction program.
And this is funded through federal funds?
Through our ARPA resources, yes, sir.
And the ARPA money was put in to sort of help all the states recover from the COVID epidemic.
Yes, sir.
Okay. Do you know the amount of ARPA funds that were allocated to the District Attorney's Office or the ORCA project?
I don't have that number available with me today, but I can share it.
And as far as the expenditures of that fund, is that anything that the county commission had authority or discretion over where the money went, how it was spent?
Specifically, is your question specific to the ARPA resources themselves?
Yes.
Yes, sir. They determined where and how our ARPA resources would be utilized. The county executive team made a recommendation, and the Board of Commissioners adopted that recommendation, and we have modified it over the course of time as we have continued to execute on our spend for the ARPA resources.
And one of the areas you allocated some of the ARPA funding was to this ORCA project.
Yes, sir. In total, about $75 million is what we allocated to Project Orca.
And who else was allocated funds through the ORCA project in addition to the District Attorney's Office?
Most of the partners from our justice system received funding out of the Project Orca resources. The District Attorney's Office, the State Court, Superior Court, Magistrate Court, Public Defender, the Sheriff's Department, I believe Juvenile Court received some. So we took a look across the entire justice system to see where we would need to plug in some additional resources in order to develop a work plan to, bring our backlog that had accumulated, to bring those numbers down.
So if $75 million was applied to the ORCA project, do you know what amount of the $75 million went to the District Attorney's Office?
I don't have the exact dollar amount with me. I can tell you that she did receive funding to cover 75 positions, which was the highest number of positions that were provided across the justice agencies. But I'm sorry, I didn't bring that. I don't have that number with me, and I don't know it off the top of my head.
I'm not certain if we even requested that. I know that you are continuing to compile for me the essentially the ledger or roster of employees employed by the District Attorney's Office, and I suppose we'll be able to break this out as you compile that data, right?
Yes, sir.
Okay. Do you have any idea how many employees in the District Attorney's Office now?
I believe she has about 277 employees, plus the positions in ORCA, so a little over 300, maybe 340.
And that would include assistant district attorneys and investigators and secretarial help, the entire spectrum of staff?
Yes, sir.
Will the ORCA funds expire anytime soon or be exhausted? I know if they came through ARPA, that's sort of winding down at this point, right?
Yes, sir. We are undertaking an effort currently to ramp down our ORCA spend within the $75 million that was allotted, and within the general time frame that was provided for the spending to occur, which is 12/31/2024.
So we're at the tail end, the last year of that, huh?
Yes, sir.
The way you described the budget process sounds very similar to the state budget process, where it's almost a continuation budget from the year before, and then there are requests for additions, increases if you need more staff or if circumstances have changed or need to make a capital expenditure.
Yes, sir. I mean, we tend to start from the previous year and build onto that. If a department received funding in a previous year that was not intended to be part of their recurring budget, then we make adjustments for that. That's why I said we provide them with a base budget, so that base budget each year will reflect the ins and the outs from, whatever transpired in the previous year's budget cycle. So if a department received funding for a particular project or purpose that's not intended to happen on an annual basis, then we pull those monies back out and readjust their and realign their base budget.
Okay. How much detail does the district attorney's office provide when they make their annual budget request? Is it fairly itemized by employee, by expenditure type, where it goes?
In our process, we provide them with a line item version of their budget in our budget development application. We provide them with a position summary. So we give them a report of all of their positions, and it's as of a point in time. And they are required to make any corrections to that position summary report, because that becomes the basis for their salary and fringe benefit budget for the base year. And then they are allowed to go in and align the operating portion of their budget in whatever manner suits their operational needs. We do have a couple of object codes that we really do not allow them to deviate much from, because they are necessary to fund things like our risk management fund. So, we have an object code specifically for that. That's a rate times the number of positions that you have. So there's no deviation there. But they do have the ability to go in and adjust their budget. They are requested to provide details, contract names and amounts for specific contracts. So like our Department of Real Estate and Asset Management would come in and identify their contractors that they have and their contracts that they have for things like janitorial services. If they have professional service contractors, they would identify them. It is an ask. Some departments do a better job of others than, providing a lot of detail and support for their asks. So, we spend a lot of time and a lot of back and forth trying to understand, especially when they have submitted for an enhancement request or a new program, trying to make sure that they've put everything in that they should be including in those requests. But they do have the opportunity to align it how they would like to see it and provide detailed explanations for their requests.
Okay. And Chairman Pitts, back to you just for a minute. That's why I was letting her get into the
Yes, sir.
minutia there, because I know that's why you hired her, right?
That's correct.
Okay. The way you've explained it to me is that with certain elected officials that are provided for under the Georgia Constitution, like the District Attorney's Office and the Sheriff's Department, these are elected officials, and our state constitution provides the sort of parameters of their authority and responsibilities, right?
That's correct.
For those, particularly those two, a sheriff and a district attorney, do you micromanage their budget, or is it fairly well left within their authority under the state constitution?
Well, they're what we call constitutional officers, and we have 3 or 4 of those. And then the district attorney is in a sort of a different category. But also, now I'll have to defer to get the correct terminology from our county attorney. But constitutional officers believe that once their budget has been approved by the Board of Commissioners, then they are free to manage that budget any way they see fit. And that's because of this law, I suppose, that gives them that authority.
So you can't micromanage their spending once you've granted them the budget, appropriated the money to them from the general funds?
Probably not. And that's, I guess the answer to that would be no, we cannot.
But essentially, you don't have to appropriate money to them unless they can justify for you why they need it and what they intend to spend it for. The
Well-
line item listing that Ms. Whitmore just referenced.
Right, when the departmental budget comes to us and say, even with the constitutional officers, there are line items, but we fund the line items and that results in a total. But once we've approved it, they can disregard the line items that we have approved, and therein lies, I guess, a source of conflict from time to time.
Do you have a good grasp on exactly how much money runs through the DA's office budget every year? You know, 36.6 million comes from your general funds from the taxpayers of Fulton County. And then they have money that they get from these forfeitures and from a portion of fine money. And then they may have grants, et cetera, both state and federal on top of that, correct?
Yes, sir.
And then the state itself funds a certain number of positions, including the district attorney's salary and a certain number of assistant district attorneys based on the number of judges in the circuit.
That's my understanding, yes,
Okay.
sir. But we do not monitor that. So what we are aware of is that the 36 plus million that comes from the general fund, and rarely do we keep up with how much they've received from grants or fines and forfeitures and things of that nature.
Right. That's something that's within the control of the district attorney's office.
Correct.
Okay. Do they ever report that amount to you? I mean, it would seem in the course of making a budget request to you, they need to show a need for money, and that would necessarily require them to show you what they're getting from other sources to figure out what they need from you.
As a matter of course, that is not provided to us. Now, whether that is made